Hello, I am Jawan Strong, the realtor and owner of Dreams to Keys Realty, and I would like to welcome you to our channel. Make sure that you like this video, subscribe to the channel, and hit the notification bell so you don't miss any information that we post here. Welcome once again, and this video is about, is real estate changing? So I want to get into this video. It was intentionally scheduled as a live, but there were some issues with StreamYard. So we're on here now posting this video, and I hope that you find this information helpful and that you get curious about real estate. And if you're looking to be a homeowner, consider Dreams to Keys Realty and myself as your realtor. Now let's get into the topic. So the reason why I decided to make this video is because there was a lawsuit in Missouri that involved the National Association of Realtors and two other brokerages that are called Home Services of America and Keller Williams Realty. So anybody that is a real estate salesperson that also uses the term realtor is somehow, associated with the National Association of Realtors. So that's the umbrella name, and then there should be state associations of realtors as well. So for myself, I am a realtor, and that means that I am up under the National Association of Realtors and the Georgia Association of Realtors because Georgia is where I have my real estate salesperson's license. So this lawsuit in Missouri came about where there were previous sellers, I believe it was sellers, and of course, everything that I'm mentioning in here is my opinion and for fair use. So this is all alleged and in my opinion. So there was a lawsuit in Missouri between sellers and the National Association of Realtors and those other two brokerages. Keller Williams Realty is pretty popular, at least here in the South, and Home Services of America. So the defendants were the National Association of Realtors, Home Services of America, and Keller Williams Realty. And the plaintiffs were sellers of homes, of course. So I want to also point out that prior to this lawsuit, prior to this verdict, there were two other firms that settled out of court. And the total for that settlement altogether for those two firms was $140 million. Right. A lot of money. So the other firms were Remax and Anywhere Real Estate. Again, this is all alleged in my opinion and for fair use. So when it comes to this lawsuit, so at the point where there's already a settlement that has been reached with these other two firms, and then you have a lawsuit that was still going on in Missouri. So essentially, what it comes down to, in my opinion, is who is going to pay for the buyer's agent's commission. So I think there's a lot of things that are unclear for just the general public about the buyer's commission. Because even when it comes to conversations that I have with potential clients, as we're looking at the agreements, the buyer brokerage agreements, or seller brokerage agreements for that reason, um, a lot of people assume that if you're the buyer, that the seller's just going to pay your commission, the one that you're agreeing to in the agreement with the buyer's agent. And so it's clear in the language to me on the GAR form, which is the Georgia Association of Realtors forms that we use in real estate transactions traditionally. It's clear language to me that says if the seller or seller's agent pays anything that offsets this commission, and again, this is referencing the buyer brokerage agreement, which is between the buyer and the buyer's agent. So they make an agreement before a home is even found. So in that agreement between the buyer and buyer's agent, in that language on the GAR form, to me, it's clear that the language says that in the event that the seller or seller's agents don't make any contribution toward the commission, that it is your sole responsibility as the buyer to pay this commission, because essentially the agreement is between the buyer and buyer's agent. So when you come to the table looking for a home, be aware that that could be your responsibility. And so when we think about, is real estate changing in this way, I think the spirit of real estate is not changing because that language has been there, but the application of it could be changing, because a lot of people come to the table thinking that if I'm a buyer, the seller's just going to pay the commission that I'm agreeing to. And you have to be aware that that may not be the case for you. And in this case, that's from Missouri, in the case with the National Association of Realtors, Home Services of America, and Keller Williams Realty as defendants against previous sellers, that was a part of the issue. So the case comes down to, in my opinion, who should pay the buyer's agent's commission. And so I told you what was referenced in the GAR forms here in Georgia. And of course, this case is in Missouri, and I don't have access to those forms. But I would assume if realtors are involved and we're all under the National Association of Realtors, that the language would be the same. However, that's also an assumption because I've never seen those forms. So when we look at culturally, the seller is thought to be responsible in a lot of people's minds. The language, however, makes it clear that the buyer is the ultimate responsible party. Someone else could contribute in the transaction, such as the seller or seller's agent, but the ultimate responsibility or obligation lies with the buyer. So that is written in the buyer brokerage agreement with the agent. So is that changing? No. Is the application changing? Possibly. It could be possible that maybe that language would change at some point to where it kind of takes the seller out of the equation. I'm not sure. But in my opinion, the spirit of it is not changing because that is the spirit of it. So that is not changing based on this lawsuit, in my opinion. I don't foresee that changing. So the defendants in this case, again, were the National Association of Realtors, Home Services of America, and Keller Williams Realty. They lost this case because the jury found them liable. So it was a jury that made this decision. And so what the defendants argued, the defendants being NAR, I'll just say NAR for National Association of Realtors, and Home Services of America and Keller Williams Realty, what they proposed or argued is that commissions are always negotiable, sorry about that, and the split helps buyers who have down payment costs, closing costs, inspections, appraisals, moving costs, etc. And I'm not sure if my previous perception was brought into that argument from articles that I saw. And like I said, I haven't seen the Missouri's forms, but the language in the forms actually says, what I mentioned before. So I'm not sure if that was brought up in the case or not. If I was involved in the case or was a part of it, I think that I would have asked for that language to be presented as evidence to say that, the buyer's responsibility. But I'm not sure how this um, case was presented in court or to the jury. But again, that may have also been beneficial to the sellers to say that. So, yeah. So they argued that commissions are always negotiable. I'm not sure why I can't say that word today, but negotiable. And that's true. Essentially, there's a blank there on the form. It's filled in. It could either be a percentage or an amount, or if it's a lease type agreement, it's an amount based on the lease. If it's a separate commission by lease, there's a section for that on our GAR forms. Again, I have not seen the Missouri forms. So that is negotiable. You have an option to talk that out, agree, disagree, and make sure you're clear on that. So that is between, and I'm speaking right now based on the buyer brokerage agreement. So that is something between the buyer and the buyer's agent at this point. Now, when it comes to making offers, counter offers, and all of those things, everything is negotiable. Everything can be negotiated. So, in my opinion, I'm not sure what happened in the offer, counter offer stage of negotiation because, like the language says in the buyer brokerage agreement, the seller doesn't have to pay those things. So, is real estate changing? The spirit of real estate is not changing, in my opinion. The application of it could very well be changing. We really could be applying it based on the spirit as we move forward. So, that's my opinion there. And yes, the seller helping to pay the buyer's agreed upon commissions with the buyer's agent does help to offset costs because costs build up for the buyer when they start, doing those inspections, moving costs. And if those things weren't already factored into the deal in some other way, then it does help offset that with the seller contributing to the buyer's commissions. And again, everything could be negotiated. So there could be a seller that says, I'll only give so much, or I don't want to give anything. And as a seller, you know up front that that could potentially mean that this buyer backs out of the deal if you're not contributing. So it may not be such an issue between the NAR as it could be just that buyer. You know what I mean? Like it could be that the buyer is saying, well, if they're not willing to accept this, if they're not willing to contribute to the commissions, then I don't want this home anymore. And that's a decision beyond the agent. That's a decision that the buyer is making. And the agent is just operating on the behalf of the buyer. So I'm kind of unclear what happened in court with that part because to me, the ultimate decision makers in this case, to me, would be the buyer and the seller, not necessarily agency, right? It depends on was the buyer and the seller, were their agents operating in the way that they hoped? Was there any mismatch there? And again, back to the question, is real estate changing? The spirit to me is not changing. It doesn't mean that this case causes for less use of realtors. I've heard that and seen that in different videos. And I don't think that that is what this is stating. I think that what this case presents to us is that how we've applied things traditionally or thought of things traditionally is not always in the spirit of what is on the form. So when you, like I said before, and what I mean by that is if you come to the table looking to buy a home, do not assume that the seller will pay the buyer's agent's commission. If you come to the table looking to sell a home, do not assume that you will have to pay the buyer's agent's commissions. Be willing to negotiate, be open to negotiate, and be prepared financially for those costs. And I will discuss in other videos about strategies for saving because I do have different strategies that I think could be helpful for just your everyday life and also for saving if you are looking to buy a home or make any big purchases in the future. So if that's something that you're interested in, definitely hit the like button, subscribe, hit the notification bell, and leave me a comment and say, teach me how to save. And I will get on that video and get it posted. Okay? So I think the question for me as a realtor, when I read this type of information and think about what is actually in the forms, is what really went on between the buyer and the seller in their minds, because even though they could, the agents are talking, what was the conversation? And based on how we operate as agents or realtors, those conversations are confidential. So I'm not asking to be privy to that information. But what I am saying is there needed to be some dialogue between the buyer and buyer's agent and separate dialogue between the seller and seller's agent on what their goals are. And it's up to the agent to communicate the goals from each party to the other agent so that the goals of that party they represent are best upheld. And it could have been more of an issue of buyers' wants and needs versus sellers' wants and needs, and the wants and needs affecting the commission. In my opinion, I don't foresee how the conversation became more of against the actual realtors or the brokerages. To me, that seems like more of an issue based on what the buyer and sellers want. But again, is real estate changing? I don't think the spirit of real estate is changing. This is another reminder to read the documents. When someone gives you forms in general and real estate related forms, make sure that you read the documents because this spirit is already outlined in those forms. And I refer to GAR forms as the Georgia Association of Realtors forms for real estate transactions. Specifically, when you look at like buyer and brokerage engagement forms or seller brokerage engagement forms, what have you, exclusive or non-exclusive, those forms have this spirit already there. Application in practice or in a particular deal could be different because of the needs of the buyer and seller, but that is something that can be negotiated. So, is real estate changing? In this particular lawsuit, I don't think that it changes a whole lot immediately. I think that the application of the spirit of real estate will change. And the mindset of those going in to buy or sell homes will change. But the spirit, I don't think is changing. And I want to make sure that I'm clear on that because, like I said, that information, that spirit of what is intended to happen, who's really obligated for the buyer's agent's commissions, has already been in the forms saying that that's the buyer's obligation. So if you accept a deal and you don't want to, as a seller, pay that commission, don't, be aware that you accepted that, in my opinion. And don't feel pressured to accept that. Now, I'm not sure what pressures were presented because the jury did find the defendants to have lost this case. But yeah, and reading the GAR forms, like I said, it's already there. So if you don't like something about your deal, you negotiate it or you move away from the deal. You don't move forward. And that's just how I see it. All right, so short-term effects for buyers and sellers. I don't think this affects anything immediately. Nothing I think changes. I think some people may say, well, I don't want a realtor. And I think that that is your choice. However, I don't think this case alone would necessarily, even if I'm not a realtor, though I know I have a bias because I am a realtor, I don't think that this case in and of itself means don't use realtors. I don't think that's it at all. I don't think that it diminishes the use of realtors. If we're clear, a lot of people use realtors because of the benefit of having someone do all the tasks and have all the conversations and speak for you when you're not present, when you need to work and take care of your house and home and kids. You have someone in the background negotiating on your behalf, making those phone calls, having a tough conversation, speaking up for you when you're not available. And so I think that's still very beneficial. And I think that people somehow associate this lawsuit case as a means to say, well, I don't want to have a realtor, and also because I don't want to pay the realtor's commissions. I think also that plays a part into this case because of the amount that is being granted to the plaintiffs in this case. And I want to say it's $1.8 billion, but if I'm wrong, I do apologize for that. I don't have that number in front of me. But I do think that there's another part of the forms with the buyer brokerage engagement because I keep going back to buyer because it's the buyer's agent commission. I think that was the biggest part of the question in this case. So with that buyer brokerage engagement agreement here in Georgia, and I know that this case was in Missouri, and I have not looked at those forms. I don't have access to those forms. But in our forms, there are blanks there, and the percentages or specific numbers can be filled in. So that is agreed upon between the buyer and buyer's agent. And like I also mentioned before, there is another section that outlines what that means and whose obligation it is to pay that. And it outlines that clearly, that the buyer's ultimately it's ultimately the buyer's obligation. The seller or any representative of the seller, in that case, like the seller's agent, could contribute, but the ultimate obligation is the buyer. And that language is clear to me in that form. So I do not think that, again, real estate is changing in a way where we're just totally not needing realtors, not needing agreements, not needing engagement agreements or anything like that. But I do think that we need to shift the mindset of the buyer and seller to be more aware that this is a negotiation, and read the documents, because the documents are clearly outlining what should be happening here and whose obligation different things are. The GAR forms also communicate what the duties of the buyer and the broker are, and the broker's affiliates. So as a realtor, I'll be considered sorry, the licensee and affiliate up under the broker. So knowing who, what chain of command you have. So short term, for buyers and sellers, I don't think anything is changing. You still have your choice to use a realtor or not, and realtors still are paid by commissions or a different agreed upon um, either percentage or a price. You negotiate that at the time that you decide to work with the realtor and establish a realtor client relationship. So whether you're a buyer or seller, that's something that in your agreement you work out, and you're prepared to pay in the event that the other party does not.